Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. If you're enjoying this legal education content, please remember to subscribe. It helps the channel grow. For today's case, we have one coming out of the armed forces. This is United States of America versus Hennis. In this case, Mr. Hennis, a master sergeant, was accused of killing various other people, and he was called back into active service for the purpose of trying him and convicting him and sentencing him to capital punishment. So we're going to learn a little bit about the story of Mr. Hennis and what the role of the UCMJ and military law is. Let's get started with this. Captain G.E. of the United States Air Force, his wife, K.E., and their 3 daughters lived in Fayetteville, North Carolina. In anticipation of an upcoming assignment to England, the family put an advertisement in a local Fort Bragg newspaper to find a new home for their dog. On May the 10th of 1985, while Captain G.E. was on temporary duty to Maxwell Air Force Base in Alabama, the appellant visited the family home to meet the dog. So this guy is going to be transferred overseas, and he'd like to find a new home for his pup. Very sad, I'm sure. What happened next is even more sad. On May the 12th of 1985, K.E.'s neighbors telephoned the sheriff because they had not seen K.E. or her daughters for several days. Newspapers were piling up in the front yard, and they could hear crying from inside the house. This does not bode well. Inside, responding officers found the body of K.E. and 2 of her 3 daughters, aged 5 and 3. The youngest daughter was found alive in the crib. K.E.'s jeans were discovered on the floor alongside underwear that had been cut from her body. Her wrists bore ligature marks, almost like she was tied up. An autopsy determined that K.E. and her 2 daughters died of multiple stab wounds and a large cut on the neck of each. Intact remnants was found inside of K.E. So yeah, this went from 0 to 100 real quick, as they say. So how we started the story is K.E. and husband and daughters are going to be moving overseas because they're being transferred, and they'd like to see that their dog has a good home. And while they're visiting Alabama, someone comes to meet the dog, and now the wife is dead, the daughters are dead. It's going super well. And also, her underwear has been cut from her body. And there's ligature marks on her wrist like she was tied up. And there's intact remnants inside of her. Also, her throat has been sliced. So it's going the let's find the new dog a home thing is going super, super well. Also, their baby child was left alone, alive in the crib with no one to care for them. It's that kind of story. Let's read on. In July of 1986, a North Carolina jury sentenced the appellant to death for 3 murders. Due to the admission of especially gruesome photographs of the bodies of the victims after appellant had stipulated to the cause of death as stabbing, as well as the manner in which the photographs were displayed above appellant's head during the trial, North Carolina Supreme Court ordered a new trial. So he was convicted, and because of some problems with the evidence, they set it aside and ordered a new trial. And then he was subsequently acquitted at the state trial for his second go-around, for whatever reason. The appellant returned to active duty status and retired from the Army in 2004 as a master sergeant. So this guy was initially convicted, but he was convicted at least in part because the images that were used were especially heinous, and they were displayed in a particularly prejudicial way. So there was a way to do this and a way not to do this, and the prosecutor went too far. And it was unduly prejudicial. So during the second go-around, they obviously didn't do that. So why the jury quit the second time, and who can say? Maybe he is truly innocent. I don't know. Or at least the jury thought that. But he's been acquitted by the state jury. So now the operative question is, can the federal government get a crack at him? Let's find out some more. In 2006, following advances in deoxyribonucleic acid analysis, forensic examiners established the near statistical certainty that the remnants that were found inside of K.E. were the appellants. Maybe this guy, because we had updated DNA testing. In light of this new evidence, the Army recalled appellant to the active duty. So this evidence was not available in the state trial, but some later time it became available. And we think, we have some additional evidence. It might be this guy. Now, the state of North Carolina can't try him again, as sad as that might be. But maybe the Army has a solution around that problem. All right, so in 2010, a general court-martial with enlisted members convicted the appellant of 3 specifications of premeditated murder under the Uniform Code of Military Justice. The court member sentenced him to a dishonorable discharge, forfeiture of all pay and allowances, reduction to the grade of E1, and be put to death. I don't know about the rest of that, because it's just like, why even bother? Yeah, we're going to reduce your rank to a private, and also we're going to kill you. I don't know, but yeah, it's just weird, but that's how the military does things. Okay. Appellant challenges the jurisdiction of the court-martial in several ways. Jurisdiction is the power of a court to decide a case or issue a decree. Before the entry of pleas, the appellant challenged the jurisdiction of a court-martial to try him for the charged offenses, arguing that there was a break in his service that divested the Army of jurisdiction over the offenses. So what this guy is going to argue, in large part, is that this particular court didn't have jurisdiction over me. They couldn't drag me before this court to have process. All right, let's read a little bit more about how military considers these questions. Early in the UCMJ's history, the Supreme Court limited application of Article 3's court-martial jurisdiction to persons who are actually a member or part of the armed forces. Earlier in the UCMJ history, the Supreme Court limited application of Article 3 court-martial jurisdiction to persons who are actually members or part of the armed forces. It has never been intimated by this court, however, that Article 1 military jurisdiction could be extended to civilian ex-soldiers who had served all relationship with the military and its institutions. Appellant was on active duty at the time of the offenses and at the time the charges were preferred, which is a formal sense of being charged. And the charged offenses are punishable by confinement for more than 5 years. Yeah. Therefore, the remaining issue is where the person cannot be tried in the courts of the United States or of a state, a territory, or the District of Columbia under the UCMJ. At trial, the appellant argued that they could have been tried by a state, and indeed was tried by the state of South North Carolina. So it's like, well, you can only try me if I can't be charged somewhere else. And I was charged somewhere else. The military judge rejected this argument. The Court of Appeals agreed with the military judge. It interpreted the plain language of the statute and determined that the double jeopardy clause barred the state from prosecuting, and therefore no other entity except the military could try him. All right, so this is a cute little interpretation of law here, and I'm not sure how I feel about it, except it's a very interesting read of it. So under the UCMJ, apparently, you can't be tried under some circumstances if you can be tried somewhere else. If you can be tried before a court, a state court, or a federal court. So under some circumstances, you can't be charged in a court-martial if you can be charged by one of these other courts. Okay. And so his argument was, well, obviously I can be because I was. And the Court of Appeals says, well, actually, as it happens, at the time that you were charged, you couldn't be charged in the state court because you had been charged and acquitted. So you couldn't be charged anymore. So they didn't have jurisdiction. So I don't know if that's the right interpretation or not, but the Court of Appeals for the military says it's the right interpretation. It's a creative read, but I'm not sure if it makes sense from first principles or not, but that's what they decide. So let's press on. Based on the plain language of the statute, we reject appellant's interpretation of the law. The issue is not whether another jurisdiction could have ever tried the appellant, but rather whether there was any court that could try him at the time the charges were formally issued, preferred. At the time of the preferral of the charges, appellant could not be tried in the courts of the United States or any state because at that time, double jeopardy barred North Carolina from prosecuting, and no federal court under Title 18, triable in a U.S. District Court, covered the conduct. So this wasn't a violation of federal law because it was a state-level murder. So, there's no jurisdiction there for the feds. As no other jurisdiction could try the appellant at the time the charges were levied here, the prosecution met its burden of establishing jurisdiction by preponderance of the evidence. I find that interesting and convoluted, and this guy's having a very, very bad day being on the wrong end of that argument. In O'Callaghan, the Supreme Court determined that for a case to arise in land or naval forces under the Fifth Amendment, there must be a connection between the offense itself and the military. O'Callaghan and his progeny lasted less than 20 years, however. In 1987, the Supreme Court concluded that Article 1, Section 8, Clause 14 granted Congress primary responsibility for the delicate task of balancing the rights of servicemen against the needs of the military, and the exercise of that responsibility is entitled to judicial deference. The court then returned to a pre-O'Callaghan view of court-martial jurisdiction. The test for jurisdiction is one of status. Namely, whether the accused in a court-martial proceeding is a person who can be regarded as falling within the term land and naval forces. Appellant asserts that he did not have military status such that he was subject to court-martial jurisdiction at the time of his trial. He contends the Army lacked authority to recall him to active duty, and the Army foreclosed personal jurisdiction based on his retired status when he was over his objection it treated him as a soldier. Appellant's claim that the Army lost jurisdiction over him by recalling him to active duty from retired status is without merit. The Army had personal jurisdiction over Appellant because of his retired status. The Army was also statutorily authorized to and did recall him to active duty under regulations prescribed by the Secretary of Defense. So, unfortunately for him, the Army didn't lose jurisdiction over him because of his Army status. So, they can do this if they want to. So that brings us to the end of the case of United States of America versus Hennis. In this case, we learned about a person who committed multiple murders and sexual assault and left a child in their crib to die alone. So, not great. And this person was acquitted by a state jury, and then later DNA evidence came into light, and they were they were charged and convicted by the military. And they said, well, that's not fair because I wasn't in military status at the time. And the court goes through a very painful explanation about why he was, because he had things we didn't really cover because it got into the minutia, but things that we didn't really cover was because he kind of quasi-retired but didn't. He was honorably discharged. He had a date to leave service, and so he discharged and then the next day re-enlisted, which is apparently a thing people in the military do. I guess it has something to do with the benefits or somehow the way they're calculated. I don't know. So he had a separation date. Before the separation date, he got separated, and the very next day he re-enlisted or something. So then he was attached to a reserve unit as part of his Army duties. So he's in this kind of quasi-hybrid retirement status thing. But whatever quasi-hybrid status it was military enough for him to be drawn before the military court. So yeah, it's like, we're going to bring you back to active duty and charge you and convict you of murder. And he's sad, and he'd like that not to be true. And the government has to explain to him how, being in the military works. And for the moment, that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. Until later, my friends, cheers and goodbye.